Welcome back. It's after lunch on day 2 of Paul Caneiro's trial in New Jersey, and we had a full morning of financial information from Detective Bassinder from the Monmouth County Prosecutor's Office Financial Crimes Division. She really laid it all out, and there was transfers of funds from the trust, from the account where Paul Caneiro was the trustee, and there was falsification of records submitted to the accountant, and in order to delay Paul's discovery, in order to delay Keith from finding out. And after lunch, we're going to hear, I believe, we're going to hear next the phone call that was the night before, where Keith is demanding the password to get into the TD account. That is the trustee account, the trust account for his life insurance policy, which only Paul has authority for and has. He's the only one that can take money out and institute transfers. The money that gets put in is automatic transfers from payroll. Paul is the only one else who can transfer money in and out as the trustee. They kind of laid it out in black and white. Well, I guess now we're going to see what the rest is and then what the defense has for this witness. But it seems like this witness is the only witness for today. So let's see where they're at. Okay. 112, it's 1:30.
Keeping it good. Good afternoon.
There he is.
Everybody can be seated. Everybody have a good lunch? Feeling strong?
Yeah.
Stretch out a little bit? That's what I like to hear. All right. We're back on the record at State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. Can I have the appearances of counsel for the record?
Prosecutor, Assistant Prosecutor for the State.
Good afternoon, Your Honor. Monika, Mastellone, on behalf of Mr. Paul Caneiro, Mr. President.
Good afternoon, Judge Andy Murray, Mr. Caneiro.
Okay. Good afternoon, everyone. Good afternoon, Mr. Caneiro. All right. We're going to continue with the direct examination. Prosecutor, when you're ready.
Thank you, Judge. Detective, prior to the break, I had showed you S66. Do you recall that? And did you indicate that your initials were on here?
Yes.
Okay, Judge, the state would seek permission to publish. And just for the record.
Counsel, any issue?
No, Judge.
Okay. Go ahead.
Just for the record, it's broken up into 2 parts. It's S66A and then B. So if we could play A first and then B.
All right. S66A. I feel like we have an echo, or it's in my head, one or the other.
You have an echo.
Sounds good though.
Let's not play that yet until we get rid of the echo.
How about now?
Testing.
All right.
Good. Yeah.
Good? You want me to sing?
Not yet.
That's hurtful. You know, how do you know? I could be great.
You're in the mood.
Yeah, listen. All right. Prosecutor, when you're ready.
I'm sorry, Judge, if there's apparently a technical issue with the journal. There we go.
Yep. This is 66A.
Kind of like the Tony after receiving money.
The volume's going to be, I'm sorry. I don't know if it's their volume or our volume.
Can we turn our volume up a little bit?
I'm at 100.
Yeah, we'll turn ours up. Ours is maxed. Let's see what happens.
Hey, what are you doing? Kind of like the Tony that haven't been receiving money except in April. That doesn't make any sense. Canada Life, They're saying they haven't received money since April. I know it's not true. I need you to send me the statement ASAP, because I'm on the phone with them all day already. I need to access the money. Fine. Do you have it scanned somewhere? Do you have it scanned in Evernote? Can I log into it and grab it? Do you have the online access? I'll just go online and see it. You don't have the online access? If you could just see a way to send me the password, I'll do the research myself. Thanks.
Judge's next one would be S66B.
Okay.
Hey, Steve, how are you? Sorry to call on the house line. I'm looking for Paul. I know he's sleeping, but I need to talk to him. Yeah, definitely. Thanks. Yeah, please. I'm coming on mobile. Thanks. Yeah, thanks.
Can we just pause it for 1 moment? Detective, is there a timestamp on here?
I can see the duration of the call, and I can see that it says November 19th, 2018 at 18:05:27.
And the previous one, do you recall that one?
That was dated the same date, and it showed 3:50, the military time for that time frame.
Hey. I just spent the last hour and a half on the phone with the insurance company. They're saying they haven't received any money and that they took a loan against my account and they're taking another one in October, which is just in October. I need to know, show me where you're sending the checks in online. You're writing them out online. I need to know where they're going. I need you to wake up, Paul, and do it. Short of you being dead, I need to see the stuff. You need to log into your account then. You log into the TV account. Give me the log into the TV account. Your TV account, you don't know your TV login. Go find it and give it to me. I need to see it now, Paul. I need to see it. I need to see it now. I need it. I understand, Paul. I understand that. I just spent half the day. Paul, I'm telling you. I need it. I need it. I need it. Give me the fucking login, Paul. Give me the login, Paul. Paul, just give me the login so I can see where the money went. Then get on your computer and tell me where the money went. Paul, Somebody else could read it to you there. I need to know where that money went. Look a little while, Paul, and I understand you're saying you need to wake the fuck up, Paul. Paul, I'm telling you, I just spent half the day looking for this. I need to know where it went. Paul. Paul. Are you sure it went to the right place this time? You have cash checks? You have cash checks? Paul. I hear what you're saying. Paul, I'm worried. I need to know where it went. All right, an hour or two. An hour or two. An hour or two, Paul. That means by 8 o'clock.
Nothing further.
Okay, cross-examination.
That look was concerning. And now we have the cross.
So, Detective, we just heard those calls. They took place on November 19th, 2018, right?
Yes,
And you listened to those particular calls before you came here to testify today?
I did.
Those are the only calls from that series of Wise recordings that you listened to?
Yes,
You didn't listen to the calls that were made before those that we just heard, right?
no,
You didn't listen to the calls that were made after the ones we just heard, right?
correct.
You don't know if there's anything in this case of evidentiary significance that happened before those calls?
And we have our first sidebar. And it's about scope, I think. And it's also about relevance. Because this person is on the stand, this detective is not a mind reader, and she needed to stay within the financial crimes. So why would she have listened to all of the phone calls that they have from all of the phones? I know the defense needs to poke holes in things. We all know that. And I'm all for it because we want a fair trial for Paul Caneiro. We want the evidence to be what it is. We want less chance for appeal or delays or overturning on some silly thing. However, there's such a thing as relevance, and there's such a thing as reasonableness and scope. And Judge Lemieux doesn't play like this, okay? And Andy Murray's style is to just say nobody knows anything. Like, it could be this, it could be that. It could be this, it could be that. You know, there's a song like that. It's been playing in my head. The longer I listen to Mr. Murray, it's going to be interesting. I think we're going to have a battle of scope and relevance for the afternoon. Buckle up. I like the guy. I really do. He's an excellent attorney. But it is rather frustrating. And I think for a judge on J2, you don't want to do this. You don't want to keep doing this. Well, anyway, we'll be back soon.
Ladies and gentlemen, remember I talked about there may be times where I may have you take out that number 2 pencil with the eraser on it and erase it? There's one of those times. The question that was just asked dealt with phone calls before and after the 2 that you, or the 3 that you hear. What I want you to do is I need you to erase that from your mind of any other calls in this case at this point in time. The court may have made rulings at some point in time that maybe has an impact on this. So you're hearing what you're going to be allowed to hear, at least right now. So I don't want you to have any thoughts about that one way or another. There should be no impact on either the state and or the defense on this, but we are not to infer anything else that may have gone on that you're not being told, and why aren't you being told? Does that make sense? All right, can everyone follow that instruction?
Yes.
Thank you. Go ahead.
Excellent ruling. Bravo, Judge
Yeah.
Lemieux.
You testified today about a number of financial transactions between a trust account that you referenced and Paul Caneiro's personal account or accounts, right?
Yes.
You're aware that in April of 2018, there was an issue that Keith became aware of about money from the trust not getting to the life insurance, right?
Yes.
And when Keith found out about that in April of 2018, he was upset about the fact that that was happening, right?
Okay.
You took us,
You say okay. Are you agreeing with what he's saying, or are you not agreeing with what he's saying? I'm not sure what that was.
I was listening to what he was saying.
Okay. We need to be careful, just if you don't mind, with the questions, because I don't want the jurors to be left with an impression as to an answer which wasn't really an answer to what you just said. So go ahead.
Thank you, John. I'm going to clarify it.
Please do.
You said before today that you spoke with a witness in this case, and his name is Steve Weinstein, right?
Yes.
And you took a formal statement from Steve Weinstein, right?
I was a part of that interview.
Yeah, you were there when it happened,
Yes.
right? And you were able to hear what he said, right?
Yes.
And you were able to review that, if you chose to, at a later date, after it was reduced to writing, right?
Yes.
Okay. Now, during the course of that statement, Steve Weinstein is asked about that incident in April of 2018 with the life insurance money, right?
Yes.
And he explains what took place in that time period, right?
Yes.
And he explains that Keith found out that the money wasn't getting to the life insurance policy, right?
Yes.
And he explains that when he found that out, Keith was overly upset with everyone.
I didn't memorialize that statement. That was not my lead on that statement. But if you want me to testify as to exactly what occurred in that meeting, if you have a statement or a summary of that, I can look at it.
Judge, I'm going to approach. This is S9.
Okay.
Detective, just so you can see the front of this.
Sure.
This is marked S9, okay?
Yes.
Do you recognize this to be the statement of Steve Weinstein?
Yes,
Okay.
yes.
And I'll just show you on the last page of this document, we're going to see a date and a time, which is January 24th, 2019, right?
Correct,
5:23 p.m.
correct.
Signed by Steve Weinstein,
Yes,
signed by yourself.
on the third signature, yes.
Sure, but you signed it, right?
Yes, I
Signed
did.
by Detective Petrosello,
Yes,
signed by Detective Zarello.
correct.
Okay. Drawing your attention to page 6, I'm just going to ask you to review that page, lines 4 through 8.
Yes,
Okay. You had a chance to look at that, right?
I did.
And then, so what I was talking to you about before was this situation in April where Keith finds out the money's not getting to the insurance company, okay? And in that statement, am I correct that Steve Weinstein's going to tell you when Keith found out about that incident, he was overly upset with everyone?
Yes,
Those were his words, right?
yes,
He didn't say upset with Paul. He said overly upset with everyone.
yes.
Okay. I'll take that back.
Sure.
Thank you.
You're welcome.
Now, you.
Thank you.
We also know that, let me see if I can confine this way. You testified earlier that you watched the 3 Wise camera videos that we saw today, right?
The two videos.
If there were conversations about the issue that happened in April of 2018, right? We wouldn't know that were recorded. We wouldn't know because we haven't seen those, right?
Right,
Okay. So we didn't have a chance, other than the statement of Mr. Weinstein, to see Keith's demeanor back in April of 2018 when he found out about the issue of money not getting to the insurance policy.
correct.
Now, we also know that you're here talking about finances in this case, not because it's somehow, independent to the charges, but it both supports charges in this case, right?
Yes,
And it also goes to the essence of the state's theory of motive, right?
correct.
And so this financial evidence goes to the heart of the state's theory about why Paul would kill Keith, right?
Correct.
This call, in the 2 clips that you mentioned that we just saw, matters because in it we can see Keith trying to figure out if the money is getting to the insurance company in November, and he's trying to figure that out from Paul, right?
Can I just clarify what he's trying to figure it out in November for what happened in months past? Is that what you're asking? Yes,
In November, right. In November, we just watched these calls. They take place on November 19th, and it's about whether the money has been getting to the insurance company, right?
yes,
And those calls are meaningful to the state's presentation of motive evidence in this case, right?
Yes,
And they're relevant because not just for the content, not just for the detail about the finances, they're relevant because of Keith's apparent emotional state while those calls are taking place, right?
yes,
But you did not know Keith Caneiro personally, right?
no,
And you did not know and do not know what his general demeanor and emotional character were, right?
no, I did not.
And all we have in terms of your review is what we can see in terms of what's on that video, right?
Yes,
But we know that Steve Weinstein said about the April event that Keith was overly upset, right?
yes,
We also know that in between April and November, Keith and Paul continued to speak to one another, right?
I wouldn't know that.
They continued to be in business together.
Correct.
There was a plan, a proposal to perhaps sell one of their businesses. You're aware of that,
Yes.
right? And that took place in the latter part of 2018.
Yes,
It took place after this event in April with the trust issue.
it may have.
Okay. If I told you it did, would you accept that?
I would hear that you're saying that.
Okay. Well, I don't need you to, but let's just say, they were working on that sale. Okay. Did you know that, and so that's your impression that they were working on that together, right?
Is it an impression? I just know that EcoStar was hopefully going to sell.
Then we get to November, and what we're still dealing with is this issue of whether money's getting to the insurance. And the issue is it coming from the trust to the insurance policy, right?
Yes,
You documented for us today what that amounted to in terms of transfers from the trust to places other than the insurance policy, right?
yes,
And that was about $33,000 in 2017, right?
yes,
And about $44,000 in 2018, right?
44,500.
And in total, we're talking about, in terms of your number estimates, about $78,000.
Yes,
Paul's on the other end of that call on November 19th of 2018. That's your understanding, right?
that is my understanding.
Paul can hear what Keith's saying.
That is my understanding.
We don't know what Paul is saying back to Keith.
Correct.
We don't know if Paul's apologizing or if he's telling his brother to calm down. Right?
Correct.
Paul knew his brother way better than you were ever acquainted with him, right?
Yes.
And I guess the issue is this. I think we touched on it earlier today. It's important for a detective in a case to look not just to the things that strengthen arguments for motive, but to look to the things also that may weaken support for motive.
Agreed. Prove or disprove.
A reasonable question might be, are there things in the financial records which demonstrate Keith's general emotional demeanor?
Can you explain further what you mean?
Sure. If Keith upset on these calls on November 19th, if Keith upset on these calls is an aberration for him, a way that he doesn't usually present, a way that his brother, who knows him very well, would find disconcerting and unusual and shocking and uncomfortable. That is a very different thing than if Paul knows this is just how Keith acts. Do you understand what I'm saying?
I understand.
So if there was evidence that could tell us whether on one side Keith's demeanor that night was an aberration, or on the other side that it was maybe a more general emotional reaction that others who knew him would see him to have, in either event, that would be important for us to know.
Are you asking me, would it be important for me as a financial detective to know?
I'm asking you as a detective who participated in this investigation with other detectives, because let's remind everyone, you weren't isolated completely to finance. You spoke with other detectives in this case, right?
I have spoken with other detectives, mainly the detectives that I was with when I participated in the interview of the CPA, Steve Weinstein, when I participated in the interview of Ron Artigas, when I participated in the interview of Tiffany Rivera, also a financial interview, and in speaking to Yusel Restrepo. So I have not been a part of any other interviews. I follow the money. Okay. I am a detective in the financial crimes unit.
Yeah, but you're a part of this case, aren't you? You're a detective in this case.
Technically.
Okay, let's stay with technically. That's fine. But technically, you're a detective in this case, right?
Investigating the financial aspect.
And technically, you know what the state's motive theory in this case is. You already told us that, right?
Yes.
And technically, you know that the state is looking for evidence that's supportive of their motive theory, right?
Yes.
And technically, you know that whether you find things that are supportive of or weaken the strength for that motive, it's important for you to note that to others involved in the case, right?
Financially speaking, yes.
If you see things, so this is the point then. If you see things in the financial records that go to a determination of whether Keith's character on those calls was an aberration or part of his general character, it's important because it either strengthens that motive or lends to the idea that there may be less support for that motive, right?
Right?
Okay. So, if there was in the financial records an indication that Keith was a very high-strung guy, that would be important for you to know.
I'm not sure I follow you, but if you can give me an example of how the financial aspect of the investigation would connect with that, I would understand you better.
I thought I just did that for like 10 minutes. Did I not do that? Okay. The motive evidence you're aware of, right?
Yes.
We talked about the fact that that Paul knows his brother very well and you don't know his brother at all, right?
Correct.
We talked about the fact that it's important as to whether this is unusual behavior for Keith in terms of his emotional character on those calls, or whether it's usual behavior, right?
Yes.
You've agreed with everything I've said so far, right? And then you agreed that if there was evidence one way or the other to support either of those contentions, it would be important to note for others in the case. And you agreed with that, right?
Yes.
Okay, so now we're at the point where I ask you if there was evidence in the financial records that indicated Keith was a high-strung guy who could flip out at the drop of a dime.
Judge, I'm gonna object.
Can I see the attorneys, please?
Okay, another well-deserved sidebar, because this is the financial crimes detective, and he's trying to do demeanor. He's trying to act as if she has some psychology background. Now, we all know that law enforcement, well, they delve a little bit in socialism and psychology and, so a little bit of training there. She wasn't declared an expert in this. Is the way I look at it, and I'm not an attorney, but to me, it seems it's out of scope. To me, it seems irrelevant to this witness. It doesn't mean it's irrelevant to the case. That's not what I mean. Of course, it's relevant to the case. Both of their frames of mind are pertinent and relative to the motive. Absolutely. But for this particular witness, and actually, I also think it's a violation of procedure because clause is limited to the scope of direct. And I don't know if Nicole Wallace actually opened up the window to demeanor speaking to this witness. I'm trying to go back. It's been a long day. Any of you that catch it in the comments, please let me know. But I don't think she opened the window to Keith's mood. Was it the phone call that did that? No. The phone call was played to say that Keith was demanding the passwords to get into the account that only Paul had. It is proof that only Paul had access to that account via the internet and to get in there and see the actual bank statements and get the real bank statements from TD. Keith, well, it's his life insurance policy and it's his trust, but he doesn't have that access because he's not the trustee. So, but they didn't play it for demeanor, and you can hear that he's upset. So I kind of see why they're kind of doing what they're doing, but I'm really curious on what Judge Lemieux is going to be doing, because his last call was spot on. His last call was spot on, in my humble opinion. I'm sure there'll be those of you that disagree, and please, we can discuss it. Comments are open to everybody. for all sides, okay? And I don't argue, we discuss. Like, there's no right or wrong. This is all interpretation. It's just like you're on the jury. And if we had to go into the jury room, we would have to discuss it amongst ourselves and deliberate. It should be the same. So it's no right or wrong, you know, respect and discourse. But hey, we'll be back after this one. I am really curious to see what Mo's going to do with this. But that was interesting, but we couldn't hear anything. Gonna try not to make too much of it, though. I mean, you never
I'm still
know.
not sure.
People are just
And then I'll give the state the chance to respond.
Judge, do we have a way, we have the record electronically. Could we bring it on the screen? And
I don't want it going out to the world right now.
Is there a way we can-
I don't know what it says.
yeah, I can,
That's a part of the problem. You don't have it printed?
we have it. We didn't anticipate today that this witness would be entering these WISE videos because we had been told by the state that a different witness would be entering these videos. And I didn't even anticipate, Judge, going into this line of questioning with this witness until it was told to me during a break that this was the witness who was going to be doing this.
Okay.
So,
And we understood that this morning, which was before the break, but nothing was printed out during the break with the understanding that you were going to go down this path. I would assume because you seem to be referencing something that leads me to believe that you were going to go down this path after lunch.
I was going to have to, Judge, because we don't have a printer here, I was going to have to show it to the witness on a screen.
Are these documents anywhere else? Do we have them somewhere?
Judge, I mean, if they could be identified, we probably have the financial records in the building. I mean, we have the financial records in the building.
I'm talking about that we don't have them here in this room.
We have it in a conference room down the hall. If we were told exactly what they're looking for, yes, we could get it quickly.
Didn't Mr. Gonzalez say we can turn off these screens and only have these ones on? He said as the witness's screen would still be on with ours, but the big ones could be turned off.
Can you do that, Anna?
Anything here in about 2 seconds?
Hold Dave up, please.
She's on.
Dave, can we look at a document just on our screens on council table and at the witness box and in my monitor without showing it on screens?
Yes. Before you plug in the laptop?
Oh, are you plugged in?
I just plugged it in.
Thank you. The witness is going to need to see it, though.
Dude, she can pop over and look at our screen or the state screen
Let me see the document first. Right, you can bring it up.
I have it on my screen.
So it's not on my screen either?
it's not on our
It's
screen.
not on any screen.
You guys have to go to the front.
Are you sure?
The front right there.
We're ready at
It's
this
ready to
table.
be shared.
I can see it. You scroll down for me?
Is that
Well, this
good? Or keep going?
It's about evidence.
Just
they
stay right
want
there for a minute,
me.
please.
That they didn't bring forward. And it was the
You going down?
videos that caused this line of
That's the end of it.
cross.
Okay.
Okay. That clarifies it for me. But Judge Lemieux wants to see the actual document they're talking about that they want to give to the witness.
Detective, do me a favor. Come on up here for a second. You can come on all out. Yep. Feel free to sit down and make yourself comfortable. I want you to read that email.
Oh, so it is an email.
If I have to scroll down, do they scroll
They're
or I?
gonna do it for you.
Okay.
No,
Oh,
they'll do it.
hold on.
I appreciate how careful Judge Lemieux is for both sides, for the rights of the defense, the rights of Paul Caneiro for a fair trial, not to go, and also for the prosecutors, so for the rights of justice, the victims in this case. And he goes right down the middle. With him, it's the law. And with him, it's like he wants to know where you're going with stuff, and he wants to be kept informed. And he's still a little annoyed. I mean, I understand
Can you scroll down a little, please?
the defense's position that they're in, if they weren't aware that those videos were coming in with this witness, but now that they had a whole thing planned when those videos came in, so now they're trying to back into that, and I can understand their frustration.
Can you scroll up so I can see the date of this email?
And I can understand how upsetting it is for everyone, actually,
Okay, you can go back to
Including
your
the
seat.
witness.
Thank you.
Thank you.
because I think all of these demeanor questions are throwing her, honestly. Not her forte. Difficult to use
Outside the
with.
presence of the jury, you can ask the questions you want to ask, and then we'll go from there.
Okay, Detective,
No jury.
let's just start with everything I had asked you up to the point where the jury got excused, okay? Given that testimony, here we have a record that was in the Bates discovery, right?
Yes.
And we see that it's an email communication,
Yes.
and this is from the TD Bank emails that were turned over by TD to you, right?
Yes.
And it's in reference to, you would place it in a report, but it's in reference, not this specific document, but the emails themselves are in reference to Keith Caneiro's attempt to get a mortgage refinance, right?
Right.
And this is within those, and by the way, I think it was several thousands of documents that were in there, right?
Yes.
And this is one of them, right?
Yes.
But what this email does talk about is Keith being a high-strung guy, right?
I think when anyone owes the IRS money, my experience having come from IRS, they're all high-strung when they owe IRS debt.
Okay. But this was about a refi.
Because he had to pay, he also wanted to use the funds for an IRS debt.
Right. So the email says he's a high-strung guy,
Yes,
right? The email says that he'll flip out at the drop of a dime, right?
it did.
And that is clearly something that could be informative to us about whether Keith was, on the November 19th videos that we watched, a high-strung guy, right?
Right.
And clearly could be informative in that same instance about whether he could flip out on at the drop of a dime, right?
Correct.
And we also mentioned before that whether something supports or weakens the strength for motive, it's important to make note of it in an investigation, right?
Yes.
And so either way, this gives us some insight potentially into Keith's emotional character in general, right?
It could.
So in either case, it could be important to note, right?
It could be.
So it would be something that could be important to note, not for you financially, but for the case detectives who are investigating the homicide in this case, right?
Could be.
Okay, I have no further questions.
Ms. Wallace.
Judge, the state's position.
You have any questions first?
Detective, have you ever seen this before?
I'm certain I probably have, but again, there were tens and tens and tens of thousands of documents in this case. If I reviewed a document a one-off time 8 years ago, I couldn't physically possibly go back and review 50,000 pages to prepare for today.
Do you have any independent recollection of reviewing this?
Specifically, no, but if I received it back then, I probably had hands and eyes on it at one point.
That's it? No other questions? Okay. Prosecutor, what's your position as to this line of questioning?
Judge, the state's position is that this is not relevant. The state fails to see how a one-time email from an individual who we don't even know who this individual is on September 14th of 2016 can characterize the victim's general demeanor. The detective has testified she doesn't even recall seeing this. However, should the court allow this line of questioning, the state submits that it would open the door to each and every reaction that Keith Caneiro had to somebody else and things he said to somebody else when he was upset that upon learning that his brother was stealing from him.
I'll hear from you. Here's my problem. I got plenty of them when it comes to this, but let's talk about it for a minute. You want to use an email from 2016 from two different people in this case, neither of which are a part of this case, and you're offering it for the truth of the matter asserted that he is a high-strung guy, Keith Caneiro. That's what you're offering it for, because you're specifically saying that that would be important to the investigation one way or another when you evaluate all the evidence as it relates to motive. So what you're offering it for, you don't have the ability to do that unless you're calling this witness. And they're not on the witness list. Are you planning on calling them and you just didn't put them on the witness list? Because how else are you going to get this information in?
We had no intention of calling them, Judge. We had the intention at this point in time of just asking Detective Bassinder about it for the purpose of lack of investigation into the case.
So here's the second part of the problem, though. You just crossed this witness about, you don't know Keith Caneiro. You don't know if the reaction that he had in this is something he does all the time or if it's an aberration. How do I know, or how does anyone know, that Susan Baldwin, how she knows him? What's her foundation of knowledge to know whether he's high-strung or not? We have nothing. in this case. And you're putting the court in a position, and ultimately yourselves in a position, that in doing this, by asking these questions, I need you to understand, to this court, first of all, I don't see how, evidentially, how you're getting this in. But even if I was to allow it in, I would allow the state to respond, and which includes bringing back the witness from yesterday, Keith's best friend or close friend, who testified and wanted to say more about the emotions of what went on at the 6/18 dinner, the Saturday before this all happened, that I would allow this to come out. So you got two options. And if you want, I'll give you 5 minutes or 10 minutes to talk it over with co-counsel before we do it. Number one, I still don't know how legally it fits under the evidence rules to even go this way. And number two, if I decided to agree with you, do you understand, and is it your position and a strategic decision that you want to do this, understanding that I'm going to say that it opens the door to Keith's emotional state normally, and then maybe how he felt as a result of learning some of this information about what was going on with his accounts and the money that he thought was going in a certain direction. So I'm going to give you a break. Think about this, and then we'll come back. We will start back at 25 to 3, and then we'll see where we're going at that point. All right?
Can I ask a question for clarification, Judge? Your Honors indicate, based on what Your Honor just stated, and I appreciate the opportunity to confer, so in order to do so, my question is Your Honor saying we're opening the door to general demeanor or to content? Because the Wise video is both content and demeanor. It's a very prejudicial piece of evidence in this case, though relevant. And the reason it's relevant is because they're claiming like this was the motive. Keith was very upset with Paul. So it's one thing to say we're opening the door to his general demeanor.
I don't think that's the motive. I don't think that's the motive. The motive is not what Keith's emotional state was. It's the fact that Keith has confronted Paul and what that meant to Paul and how he reacted as to the fact that he now knows that Keith is breathing down his neck and his whole house of cards is about to fall. I think that's the motive that we're talking about. I could be wrong, not my case to try, but I'm pretty sure that that's what we're talking about.
The $78,000, Judge, yes. And the state's theory is that when Paul hears Keith upset about this whole thing, that's what sparks the alleged motive. What I'm asking, I guess, is the court saying we're opening the door to other witnesses coming in here and saying, generally, he's a very calm guy, or generally, yeah, he is a little hot.
Yes.
Or are we opening the door, as the state is suggesting, to specific instances where Keith is saying things about Paul? Because that has nothing to do with general demeanor. That's content.
That would have to fit under another evidential rule, or that to allow some exception to allow that information in. I'm talking about demeanor.
Just demeanor. Okay, thank you.
All right. Prosecutors, just to be clear, that's what you were talking about in opening the door.
No, Judge, to be honest, to be clear, I would say it's both.
Then show me how it would get in under an evidence rule.
Well, under state of mind, which we litigated previously, Keith's state of mind, not to mention 106 completeness.
Well, the completeness as it relates to the demeanor, I understand where you're coming from. But if you're I would need to know what other areas that you'd be wanting to bring out. I'm blind as to what the evidence is right now. So you want to tell me what that is?
Well,
as what
I think Your Honor picked up on it previously when you were talking about Mr. Paolucci, who testified yesterday. I mean, we live in a world of, we can't bring in stuff that we know isn't admissible. I.e., hey, Ben, what exactly did Keith say? Well, Keith's pissed off that, he stole $80,000. We didn't elicit that, but now by going into like, Keith would flip out, it wasn't that big of a deal, he just always overreacted. It's like Keith's running around town for a period of months, telling Jennifer's sister, Jennifer's mother, Mr. Paolucci, that Keith's stealing from him and he wants to get out of business with him. He wants to go get a job. One of the reasons why he went back to school, he's applying for jobs. He's got a Zoom call the morning, he missed it because he was killed, with Abu Dhabi for a job interview. I mean, this is all related to this idea that like this, this was just Keith. He just flipped out. He wasn't that man. Like, it also kind of borderline, I think, intimates like that they know how Keith reacted, or the defendant knows how Keith would react without testimony to that regard. I understand. I completely agree with part one of the court's analysis, but I do think it opens up other doors to specific comments that Keith made about the thefts from him.
I'd have to do, I gotta be honest, I have to do research on that issue to know for sure if it opens the door as to that other part. I don't know the answer to that, Ms. Mastellone. I thought it was only for the first part that they were trying to bring it in for. If they're trying to bring it in for both, then I'm gonna have to do a little bit more to make sure that I'm clear before I say anything.
Sure, and I know, Judge, with respect to like state of mind, Kalia evidence, obviously.
Of course. And we're talking about State versus Kalia. Go ahead.
State versus Kalia.
Right.
With respect to statements made by a victim that don't invoke fear, like it's not like Keith saying, I'm scared of Paul. Those issues have like a heightened standard.
I agree.
Under State versus Kalia. This situation is not there. We're just talking about the idea that Keith is upset because his money is unaccounted for and he's trying to figure it out. And I completely agree with the court's kind of recitation of the state's motive. I mean, obviously we can address when we get there. Quite frankly, I think we've said a couple times today, maybe yesterday too, that we felt that certain doors were open, and yet, as the court noted, we haven't kind of ran through them. There's only so much, like restraint that can be showed in order to react to things that are being brought out. So obviously, as the court said, we'll deal with specific instances as we get there. And if we do plan to elicit something that we feel like I'm arguing right now is relevant, I will certainly, Ms. Wallace will certainly allow the court to be made aware prior to doing it.
Can I respond to that?
Of course you can. Go ahead.
So a couple of things. One of the things the prosecutor just said was about, this all goes to Keith going back to school, wanting to get away from his brother, wanting to divorce himself from the businesses. Their first witness testified that 3 days before this happened, Keith is negotiating with Doris Duke, Gooley from Doris Duke, extending 3 business proposals, one of which says we will promise you to remain in business for 4 years and potentially an additional 2. So there's that's not the full story, and it's a very one-sided narrative that the state is trying to, I think, portray. And it's not consistent with their own evidence. But beyond that, Judge, anything that Keith said, let's say to Ben, right, the few nights, Saturday night before this happened, that's to Keith. There's no link that Paul would have any knowledge of that. And in order to, I think, get into the realm of the Kalia, and without having the case in front of me at this moment, there's no nexus. And that's where the content, I think, would not come into play, because and frankly, Judge, it kind of proves our point. Because if they're saying that Keith is running around pissed about this, pissed about this, pissed about this, and then this email says, yeah, and he's pissed about this too, then that's just, again, that's demeanor. It's that he's upset.
It's also years before. It's not even like this is, for example, it's not like this email is from November 15th dealing with what's going on at that particular time. So yeah, he's fired up over the issue that we're talking about. We're talking about a completely different issue, as Mr. Murray brought out. It's a refi issue. It's not based upon anything else. And who knows, maybe he was upset about the refi issue, but maybe that's not how he normally is. He's just upset about this particular issue. That's what I'm saying. Like, we're trying to make things to mean other things in other parts of the case. And I do not see it. So here's what I'm going to say. I'm only going to address the issue as of right now as to how it relates to demeanor, conduct, not into specific acts. That would be what I would decide. So you decide what you want to do. understanding, I want to hear your legal justification to even getting this in the first place. So far, I haven't heard it. But if you got something for me, I'm more than willing to listen to it. But I wanted to be clear, the second part of the analysis, because you can win the battle and lose the war. You may win, and then you're opening the door to other things. That I'm telling you for sure. I'm going to allow them to respond to the demeanor issues. I can't say anything else because I don't know, because I don't have the research in front of me. All right, take a 10-minute break. We just went into that, so we'll come back at 2:45. Does anybody have an issue with me just telling the jurors what's going on? I'm going to walk in there just so that they know. I'm going to give them their 15-minute break right now.
No, Judge.
All right, anybody?
No, Judge.
All right, thank you. You take a break.
Well, now this is getting interesting. I have to say, Judge Lemieux, he is on it. Yeah, they got a big decision to make because they could open the door to bringing back Paul's best friend to talk about all the stuff that Paul said and how upset he was about the whole situation, to add more context to this. Wow. They're taking a break. You guys watching, listening, take a good stretch. And we're going to find out when they come back. Well, two sides to this coin. I can understand why they want it in, to prove that it really wasn't that bad. That everything's being blown out of proportion, so to speak, or just taking something is that he was upset. Well, he was upset all the time, or whatever. But that could open up the door. Judge, I do love this judge. He does not let things go unanswered in his court, and I have to say, I absolutely love that.
I did want to place a few things on the record. First,
Mr. Murray, go ahead. We're back on the record outside the presence of the jury.
Thank you for giving us that time, Judge.
Can you do me a favor? Can you just sit outside for a second? Thank you.
I did want to place a few things on the record. First, we anticipated that we were pursuing that line of questioning to demonstrate something akin to effect on the listener, and to lend that towards arguments about lack of investigation in the case. We were not looking at that as a specific instance of conduct on the part of Keith Caneiro. That being said, given that at this point in time, we really have no idea what the universe of things are that this inquiry opens the door to, I do not think we can continue it without knowledge of what that could be. So I am going to move on. I will tell the court that, because Ms. Wallace brought this up yesterday, about years outside of 2017 and 2018, we do intend to get into information about prior years in terms of at least the trust account. Now, the state, I'm sure, is going to have to respond in whatever way they think is appropriate with stuff outside of what they introduced today, but we do intend to do that. So I just wanted to make the court aware of that.
Do we think that it would have been important or helpful that in all of our pretrial motions that we filed in this case that we should have put the court on notice so the court could have decided some of these, whatever you want to bring in prior to 2017? I mean, isn't that what we were doing for almost 9 months all the time?
The detective's report and reports in this case are not just about the trust account from 2017 and 2018. They're about the trust account from 2014 through 2018.
But the issue in this case and what we're focused on, isn't it surrounding, and isn't the indictment surrounding 2017 and 2018? It's not about 2014, 2015, or 2016, right?
Yes, but we have information from that account in the discovery, and that we have reports about that account in the discovery. This witness wrote those reports.
Would you agree with me that detectives write things in their reports that doesn't mean that they may be relevant at the time of trial, but they just may be a part of their overall investigation?
I don't know if I would, Judge. I think that anything a detective writes in their report is potentially relevant at a trial.
Okay, but who decides whether it's relevant?
Well, I mean, obviously the court would decide that fact.
Well, shouldn't I know this in advance so that we could have addressed this issue one way or another?
Judge, the state, I don't think, has made any protest to the court about this information being irrelevant. The only thing they said about it is it may create a situation where they want to reference things outside of this year 17 and 18 period.
Okay.
They haven't said it's irrelevant.
All right. We'll see how it goes. Can we have our witness brought back in, please? Prosecutors, you're on notice. If there's things that I need to know about, I expect to be put on notice if you have colloquy with your counsel.
Sure.
Have the jurors brought back out, please. The cross-examination of this witness. Mr. Murray, go ahead.
Thanks, Judge. Detective, I guess let's take a step back here. You are the one who sent out subpoenas for the large majority of financial records that were received in this case, right?
Correct.
You sent subpoenas to TD Bank, right?
Yes.
You sent subpoenas to insurance companies like Sun Life and Unum, right?
Yes.
You sent subpoenas to retail establishments like Tiffany Jewelers and Restoration Hardware.
Yes.
You sent subpoenas to governmental agencies like, various New Jersey governmental agencies in terms of disability and unemployment.
Yes.
You not only sent these records, but you were the one who decided to whom you were going to send record requests, right?
Do you mean when I prepare the subpoena, am I the one deciding who goes on the attention line?
More that when you're putting together a subpoena and you're saying to yourself, am I going to send a subpoena to Bank of America? You're the one who makes the decision about whether you send a subpoena to Bank of America.
Primarily.
Nobody directed you to do that. You thought it was in the interest of the investigation to do that.
You can be directed to do that, but I can also make that determination.
And you made a large number of the determinations in this case about who to subpoena, correct?
I didn't issue every subpoena on the financial side, but a lot of them, yes.
Right. Now, you didn't make these decisions randomly. Everybody you subpoenaed, you had a purpose for subpoenaing, right?
Yes.
And when we say subpoena, we don't necessarily mean that you were telling them they had to appear in court. What you were really, in effect, doing with those subpoenas is telling them they had to produce documents and give you those documents, right?
Yes.
And the documents, when you would send out these subpoenas, you would send them and tell these organizations that you wanted certain records from certain times, right?
That's written in the body of the subpoena. You have to put a time period or else they won't comply.
And sometimes you were looking for any and all records in the name of a certain person, like Paul Caneiro, right?
Sometimes.
And sometimes you were looking for specific records from a specific company. But in either event, you would put that in the subpoena, right?
Yes.
You then wrote, prior to the supplemental report that you had referenced today, you wrote about 60 investigative reports in this case.
I don't have the exact figure, but I wrote a lot of supplemental reports.
And you wrote those reports in and around the end of 2018 through 2019, right?
I'd have to look at every single one of them to confirm.
Well, let's work backwards. I think you wrote your most recent report in December of this year, right?
Right.
And then before that, you wrote a report in July of this year, right?
Those two were regarding why we're here today with my testimony for the motive.
But you didn't write. And then before those two reports that I just mentioned, it had been some time since you'd written a report in this case. It had been years.
Probably I'd have to go back to confirm the exact date.
When you were sending out these subpoenas to these organizations, you were also selecting the people about whom you were looking for information.
Yes. Or entities.
You had an attachment to many of your subpoenas, and you referred to it in your reports as attachment A. You know what I'm talking about? And attachment A is a list of names, right?
Yes.
And the names on it are Paul Caneiro,
Yes.
Susan Caneiro,
Yes.
Keith Caneiro,
Yes.
Jennifer Caneiro.
Yes.
There's an attachment A with including Caitlin Caneiro's name as well, right?
Yes.
Marissa Caneiro.
Yes.
You got records for all of those Caneiros, right?
Yes.
But it was you who chose who and who not to list on that Exhibit A, right?
And following the money, that is what would give me the financial lead to subpoena records for an individual or an entity. So if I didn't subpoena an individual or an entity, it's probably because there was no investigative lead to follow the money for. The individuals I subpoenaed had received money in one way or another.
I took that from your testimony before, because you said you had started with the trust account, right?
Yes.
But obviously, this investigation that you conducted in terms of records requests broadened beyond merely obtaining bank statements, right?
In terms of,
You obtained records from credit card companies, right?
yes.
You obtained numerous records from American Express.
Yes. Following the money.
You obtained records from Discover.
Yes.
You obtained numerous records from various insurance companies, right?
Yes.
And you obtained records not just for Paul Caneiro in terms of his finances, but you got the bank records for Keith Caneiro as well. You got his personal banking records, right?
I did.
And you got his personal American Express records, right?
I did. I was following the money of the businesses.
And you obtained multiple bank accounts unrelated to the business that were in the name Keith Caneiro, right?
Well, they were Keith Caneiro's personal accounts.
And you reviewed all of those accounts in terms of the information that you received, right?
Yes.
Because in order to follow the money, you would need to review the records.
Yes.
Your investigation really can't be complete if you haven't reviewed everything that you've got, right?
Correct.
So I take that to mean that you reviewed everything that you got in this case, right?
Yes.
You reviewed every financial record that you received as a result of a Monmouth County subpoena that went out in this case, right?
Well, I'd like to add this caveat, I subpoenaed Canada Life. There's relevant documents that are very relevant to a financial investigation and following the money. Canada Life, did you get the money? Can you show me you got the money? Can you show me where the money was applied? So hold on. If they sent me 3 inches thick of legal documents talking about a trust, I'm not an attorney to be able to interpret the legalese of that. But to the extent that I had to review documents as it relates to the financial component, yes.
Okay. I think the idea though is this. In order for you to have a complete investigation, you need to at least have eyes on everything that you receive. Is that fair to say?
Yes, but these were voluminous records.
Understood. We're talking about tens of thousands of pages of records, right?
Yes.
But, I mean, that was your job, right? It was to review these.
Yes.
And I don't think you're here telling this jury that you didn't do your job, right?
No, I did my job.
Okay. One thing I wanted to talk to you about was your report that you had written on the history of money coming into and out of the trust account. And though we only talked about the years 2017 and 2018 today, your report encompassed more years than just that, right?
Yes.
Your report actually, you had obtained records in terms of that going back to 2014, right?
When my investigation started, yes.
Yeah. And you had actually reviewed those records from 2014 pertaining to the trust, right?
In terms of money going into the trust bank account? Can you clarify when you say the trust?
Yeah, I'm sorry. When I say the trust, I mean the trust account.
The bank account?
Yes,
TD
the bank.
Okay.
Yes.
Okay,
Yeah.
I understand.
Okay, so you had written a report about money going into and out of the trust bank account in the years including 2014, right?
Yes.
Okay. One thing that we're going to see in 2014 and 15 and 16 is that money did leave the trust account and didn't go to the insurance policy, right?
Yes.
But in 2014, all the money that was taken out of the trust account was paid back into that account.
Can I refer to my supplemental report, please?
Yeah, I'll show it to you if you like. This is S56. I have it here. You don't. Was this the report?
Can I see the front?
Yeah, sure.
Yes.
Okay. In your report, you documented the money that was both taken out of and put back into the trust account in 2014, correct?
Yes.
And
Taken out of the account being sent to Canada Life and taken out of the account sent to Paul Caneiro's personal accounts.
so in 2014, you have a record of $46,000 going from the trust account to Paul Caneiro's personal account, right?
Correct.
And that money then that same exact $46,000 goes from Paul Caneiro's account back into the trust account, right? In 2015, $27,000 comes out of the trust account and goes into Paul Caneiro's personal account. That's the record you have, right?
Correct.
And $22,000 then comes from Paul's account back into the trust account, right?
Leaving a difference of 5,000 to Paul.
Right. In 2016, your records indicate that $17,700 was taken from the trust account and put into Paul's account.
Correct.
And then $14,700 is taken from Paul's account and put it back into the trust, right?
Leaving 3,000 in Paul's account, yes.
Now, another thing that we should mention about the trust in these years, and if you need to keep referring to that, that's fine. Just let me know based on this question. One of the things that we could look at when we looked at this trust account is whether it had been adequately funded over the years in order to make the quarterly payments to the insurance company, right?
Yes.
That's something that we could do by looking to the payroll deposits into the trust account, right?
I did that, yes.
So then you know that the trust account was being funded from the J. Martin business account in 2014,
Yes.
right? And then in 2015 as well,
Yes.
and then in 2016, right?
No. Keith Caneiro was issued a paycheck in 2016. Federal withholding took out the brunt of it and other deductions. So the actual amount left in the check was zero. So there couldn't be a direct deposit. So the funding of the account in 14 from Keith Caneiro's paycheck was adequate enough to fund the payment of quarterly payments totaling $33,685.78. In 2015, there was not enough funding to fund the entire annual premium, even though it was paid quarterly, but the annual amount. So only $15,709.20 went to the premium. In 2016, nothing was paid to Canada Life.
Correct.
But $17,007 was taken out by Paul Caneiro to his personal account. $14,700 was paid back, leaving at the end of 2016, $8,000 to Paul.
Right.
And then in 2017.
But also in that year, 2016, deposits, not considering the in and out in terms of Paul's account, right? But deposits from the business account only equaled $13,526.
What year are you talking about? 2016?
Yes.
Right.
The deposits from the company only equaled $13,526. So so just my point is this, that's not sufficient to fund the quarterly payments to the life insurance.
No, it isn't. But in 2017, approximately $55,000 was funded to the account. And in 2018, approximately $53,000 was funded to the account.
Do you agree with me that the account was underfunded in 2014, 2015, and 2016?
No, I disagree in 14. I agree in 15 and 16.
Okay, but you would have to look at 14 because I believe, Detective, that it was underfunded by $4,865 that year.
We can look at the report. We can look at the records.
Beyond 2014, you also...
I'm sorry, I'll add this. If it was underfunded by $4,000, it was so overfunded in 17 and 18 that it would have made up for the difference and more.
Well, I wasn't asking you that question, though. I'm just asking you about previous years, right? You've already testified today about 17 and 18. We've heard your testimony. I'm just asking you about 14, 15, 16 at this point in time, okay? I'm also curious about the Canada Life payment history that was sent to Keith Caneiro. At some point in this case, it was also included in the Canada Life documents. I think you've seen it before. Yes. You have it in your report? Yes. Judge, I have this marked as D64. It does appear verbatim within the detective's report, but I just want to show her this document to compare the two.
Go ahead. It's D what?
D64.
D64, okay.
Are you going to go back to that date? Or do you want me just, what year are you starting?
I'm looking to July of 99.
So let's do this first.
All right.
Identify D64.
I do have it. I do.
Judge, I'm sorry. So detective, what we're looking at in D64, what is this?
This is a chart provided by Caneiro Life Assurance Company. It's a chart that starts with the first date of July 28, 1999. It has numerous columns. The first column reflects a payment amount, which back then were annual payments. And then through the years, the payments changed from annual to quarterly. So it will reflect the quarterly payments made.
Is it a spreadsheet?
It's a spreadsheet. I mean, I know you can't read the data, but you can see it's a spreadsheet. So it
It's a
starts.
spreadsheet from January 28th, 1999 until when?
The last entry date here is April 9th, 2018. Do you want me to give you the column headings?
No. I just need to know for the record. And you've seen that document before?
I have.
Where did you see it?
In
Before here.
the response documents from Canada Life Assurance Company.
Okay. So that's a part of the documents that you received?
Yes,
And it accurately depicts the documents that you received back from Canada Life whenever you received them?
it appears to be so.
Well, let's confirm that it is so.
I have a copy of it in my supplemental report, and I go back to July 28th, 99, and my last date is April. See how that's kind of cut off. It's the same date, but April 9th, 2018.
So it's same?
Same.
Okay. Mr. Murray, please, go ahead.
Now, detective, when we look at that report or that payment history, we can see that there are other years when this insurance premium, or the policy, I should say, was not paid fully for the year.
What years are you referring to?
Well, I'm looking at 2007.
Okay.
I'm looking at 2011.
Okay.
I'm looking at 2010.
Well, I just want to point out, sir, that the very first premium payment in 1999 was $29,640. And I testified earlier that the quarterly premiums totaled $31,418.60. So the premiums increased once they went quarterly. It was a lesser of a premium when it was annually. So when you're going back through those years, you would need to know when it was annual and when it switched to quarterly. And then there was a difference in monies due to Canada Life.
Perhaps, but we can see in 2004 in April that the payment was $7,854.60, which is the same as the quarterly payment in later years.
Right, but it does look then that it was quarterly.
And regardless of that fact, in 2003, we only see a payment for $16,200.
Correct.
So it would appear that in those years that we talked about, as well as the years that you've testified about previously, the policy in terms of the premium weren't fully paid.
But I would not know if the TD bank account was underfunded.
You would not, but you also saw in this case that payments were made from the TD trust account in previous years, not just to Canada Life, and they didn't just go into Paul Caneiro's personal accounts, but over the past years, withdrawals from that trust account were made into J. Martin business accounts.
My bank records in this case did not go back to 2004.
No, I don't imagine that they did.
Banks don't even retain information beyond 7 years, or they don't have to.
Agreed. The question was not that. The question was, you had indication in the trust records that you did have in the discovery, the trust account records, that withdrawals were made not just to Paul Caneiro personal accounts over the years, but they were also made to this J. Martin or Square One business accounts.
In the years I reviewed the TD bank account that held the trust bank account, I did not see funds go from the trust account back to the business.
In the years you reviewed.
If they did, if you show me the documents, then I can correct my statement, but to the best of my recollection.
Okay. Outside of the statements, did you see any spreadsheets showing transfers in and out of that trust account in previous years?
Did I see transfers out of the TD bank trust account?
Did you see spreadsheets demonstrating transfers in and out of that account?
There were transfers into the account for purposes of funding the premium payments to Canada Life.
Right.
But
I'm talking about transfers, not payroll. I'm talking about transfers in and out from the. I'm just going to show you.
yeah, if you have a document,
Sure.
please show me and I can review.
This is D41. I'm just going to show you this. You recognize that?
This is the TD bank account, trust account ending in 5465. This is January 1st, 2014 through January 31st, 2014. Okay.
Okay. Does this appear, can I just have that back for 1
Sure.
second? Thank you. You've seen this before today, right?
Yes.
You reviewed this as part of writing that supplemental report you've been referring to today?
Yes.
Okay. I'm just going to show you the period of April 1st through 30th, 2014. And I'm going to ask you to look to April 24th. And you see,
Okay.
okay? And there's a debit on this account, right?
Understood, not disputing it.
Yeah.
I wouldn't recollect firsthand back to 2014, but yes, on April 24th, there's a transfer of $11,000 back to
I don't think you have it on there.
1361. This is I do have this account. I did subpoena this account, and I would need to see the subpoena to have the name, but it would belong to one of the businesses.
Yeah, could I have that back?
Have the whole
Okay,
file?
yeah, thank you. Okay, so that was a transfer out of the trust account, an account ending in 1361, right?
Yes.
And if I told you that 1361 was a J. Martin business account that had been closed in years prior to 2018, would that refresh your recollection?
Is that the business that closed December 31st of 2012?
No.
Okay.
But you do have a recollection of an account ending in.
I do.
Okay. Okay. Now, when you testified on direct today, you mentioned that payments have been made directly from Paul's 3837 account to the trust account, right?
Yes.
I misspoke. I apologize.
Well,
What I meant to say, yes.
go ahead.
What I meant to say was payments had been made by Paul from Paul's personal account directly to the insurance company to pay the insurance policy.
Are you, which years are you referring to? The years of my analysis for my role here in this trial?
Yes.
2017 and 18?
Yes, I am.
Okay. And so your question again then is?
Paul had made payments from his personal account directly to the insurance company in order to pay that insurance policy.
In 2017, yes, he did.
On July 21st, he paid $8,000, right?
Correct?
And then on August 7th, Paul from his own account paid $11,880.
Correct.
And together that's $19,880.
Correct.
And we should point out that Canada Life accepted both of those payments.
Yes, they did.
They didn't refuse payment because the checks were sent from outside of the trust account, right?
Nope. They accepted payment as a quarterly premium payment, and the $11,880 check, the entire amount was applied to the loan payment for prior missed premium payments.
Right. Right. And the loan, obviously, we saw in D64 had existed for many, many years as of 2017.
Yes.
Judge, I'm going to ask permission to publish D64.
Wallace?
Objection.
Okay, go ahead.
Oh. Yeah, I think it's plugged in. Thank you. Just showing you the first page of D64. Obviously, when we look to the left side of that spreadsheet, we see a date.
Yes.
And then when we look all the way to the right of the spreadsheet, we see a column for loan balance.
Yes.
And that shows all the years that there was a loan balance on the policy, right?
Yes.
Okay. And we can see that there are entries on the loan balance side of the sheet going all the way back to 2002, right?
Yes.
Okay, thank you. I'm going to remove this.
Okay.
Your supplemental report talks about, you had actually listed it as a negative in the column, and it was transfers that Paul made in 2018 to the J. Martin operating account.
Yes.
You know what I'm talking about, right?
Yes.
On April 26th of 2018, Paul transferred $5,000 to the J. Martin business account, right?
Yes.
And on May 15th of 2018, I'm sorry, I should also say on April 30th of 2018, Paul transferred $10,000 to the J. Martin account, right?
Yes.
On May 15th of that same year, he transferred $11,400 to that account.
Yes.
And then again on May 15th, he transferred an additional $807 to the J. Martin account, right?
Yes.
Now, all of these dates take place late April through mid-May, right?
Yes.
Of 2018.
Yes.
You know that the issue with Keith finding out about the insurance not being paid in April, that issue happened before any of these payments, right?
I conducted my financial investigation without going deep into everything else on the exterior, like pouring in to know more about if he's upset or not upset, because I wanted to look at the financial analysis independently with no bias, no anything else in my mind, just let the numbers and the analysis speak for themselves.
Okay.
So
I guess my question, though, is more like you knew, or it came to your attention at some point in time, that there was this email involving Paul, Ron Artiguez, Keith Caneiro, and Steve Weinstein from April 11th of 2018.
Yes, at some point, yes.
Right. And that email is actually is one of the state's exhibits in this case, right?
Yes.
In that email, one of the things that, and it appears, right, that it's written from Paul, right?
Yes.
And it's about payments that were not made to the insurance company.
Yes.
Showing you S11. You recognize that?
This would be the email you're referring to?
Yes.
Yes.
Could you flip to the second page for me?
Sure.
Is there a section where what is referenced is the amount that is owed to Keith plus interest for the payments that didn't make it to the insurance company?
Are you referring to this dialogue here?
Yes.
Would you like me to read it?
I just wanted you to read the section on payments with interest. Thank you. And so that says amount owed to trust plus interest, $25,806.41.
Yes.
Okay. That email, right, was dated April 11th, 2018.
Yes.
And then we see Paul make payments between April 26th and May 15th of 2018 in the amount of $27,207.
Yes.
Right? And he makes those payments to the J. Martin business account, right?
Yes.
And then in terms of the $5,000 and $10,000 payments in April, do you know what happened to them afterwards?
I'm not sure I understand your question. How was he able to make those payments?
No. Once they went into the account, did they stay in the account or did they go someplace else?
Once Paul made those electronic transfers back to J. Martin, I would need to look at the bank statements and then I could tell you what happened with those funds.
Okay. I don't believe the state has labeled this document.
No.
Okay. Judge, I'm going to approach with what I've marked as D30. Do you recognize, I'm just going to hold the page open, okay?
Oh, okay, sure.
Do you
This-
recognize that?
This is a TD Bank account in the name of J. Martin Consulting, Inc., DBA Square One, account number ending in 1396, which would be account number 6 on the chart.
So something that we talked about maybe briefly today, but it's the J. Martin operating account, right?
Yes,
Okay.
yes,
Now, we said that the first payment that Paul made from his account to the business account took place in April 26th of 18, right?
yes. Yes,
Okay. Transfer in from Paul, right?
yes,
Transfer out to 1934.
right.
Then we got a transfer, $10,000 transfer in from Paul.
But we also don't know, once it's in 1934, you have to follow it till its final destination.
I'll take you there. 10,000 in, right?
Yeah,
And then 10,000 out.
to the same account, 1934.
Yeah, okay. Thank you.
You're welcome.
Judge, this is D52. I'm just gonna hold the page for you, okay?
Okay, sure.
Whatever you like.
Okay. So this is a TD Bank statement in the name of Keith and Jennifer Caneiro, ending in 1934. Okay,
So that's the account we just saw, that now we know that Paul's account goes to the business account, and from the business account, it goes to this account, right?
yes, but like the 10,000 goes into this account and then it's sent right out to J. Martin payroll. So Keith's putting it back into the business. And account 2949.
Yeah, take another look at that.
Okay. Right now, you'd have to show me what account that is.
Okay.
I don't recollect that account number.
Yeah, but just for our purposes for right now, we can see that both transfers into 1934 went to an account ending in 2949, right?
2949.
Both of them did,
Both of them
right?
did.
Neither one of them went to payroll.
No,
Okay,
I can see that now,
okay,
but I'd like to see the statements for 2949.
okay. Show them to you. Judge, this is D54.
Okay, and this is TD Bank statement, account ending in 2949, in the name of Keith Caneiro. Okay, so the 5,000 comes in and the 10,000 comes in. Okay,
Okay. Then the money is,
okay.
money's withdrawn overseas.
Well, they had a home there.
Right, but the money's withdrawn in Greece, right?
It is.
Okay.
But when you look at the totality, and that's why you do a financial analysis, I just saw in that bank statement that 2 entries down, over 11,000, Keith put in to a payroll account for the business. So to point out that transaction where it's going into an account that ultimately was utilized in Greece, on the same day or the next day, he's taking more than 10,000.
You asked
Right.
me to see it though.
I did.
Did you not?
But I
I
pointing out that you do a comprehensive analysis when you're analyzing the funds.
Did you analyze these funds when you did the comprehensive
I
analysis?
reviewed those statements, but I was not following Keith's money. I was following Paul Caneiro's funds
Well,
because that's what was taken out of the trust account. That's where it all started.
now, here's the thing. I point this out to you because, as you said, Keith had a house in Greece, right?
Yes,
That he was working on. He was renovating it and he needed to put money into it, right?
yes.
That's it. It's another thing that during this period of time, Keith was working on that he needed to devote money and resources towards, right?
Yes.
After this thing happens in April, on April 11th, with Paul saying he paid the wrong person and that the money didn't go to the insurance company. Paul takes $27,000 and he puts it in the business account, right?
He took loans out to generate the ability to have funds to then put back in the business because Keith identified the amount of premium payments that hadn't been paid for a period of time.
I think that, yeah, right. I think that was my question, right? But then Paul puts the money into the account, right? And then Keith takes it out of the account, right?
That one isolated transaction he took out of the account, but he also used his funds to fund payroll.
Okay. Those two transactions that we were looking at, right? My point to you is this. They don't go to Canada Life. They go to Greece for whatever purposes they were needed for in Greece, right?
Right.
So Keith, obviously, if we're following the money, Keith obviously made the determination at that point in time that the money was better put being sent to Greece than being sent to Canada Life.
Keith could not make a payment directly to Canada Life. Paul was the trustee. Paul was in the position to move that money from the TD Bank account to Canada Life.
You say that, but the problem is that we already talked about the payments that Paul made from his personal account.
But he's the trustee.
I mean, it's his personal account. The Canada Life accepted the payments.
He's the trustee. Trustee has significant control over that account, if not all control.
You're testifying as an expert on trusts?
No, I'm talking about the bank account.
You're testifying as an expert in insurance on the laws and regulations regarding checks from whom insurance companies can accept as far as irrevocable trust accounts?
No, I'm
You're not.
speaking about the bank account.
Okay, well, we're not talking about the bank account. We're talking about the fact that the insurance company accepted checks from outside of the trust account.
You'd have to talk to them as to why they accepted that.
I'm talking to you only because you said that he couldn't have made a payment himself. There's a number of things he could have done. He could have put the money back into the trust account directly, correct? Just it's a yes or no question. He could have, right?
When you open up a bank account, it tells you what you have to articulate to the financial institution, how you plan on funding that account, and it was to be funded through payroll deposits. The trustee is on the signature card and on the account. So a trustee at a financial institution on a bank account can move money in and out. In my experience in banking and my experience in financial crimes, I do know that.
Sure. My point to you, though, is this. Checks were sent to the insurance company from bank accounts other than the TD trust account. Is that true or not true?
It's sent from the trustee's name and his account. He's the trustee, so Canada Life would accept that.
And are you
Obviously, they did accept it. It's recorded as a payment received.
Are you insinuating, though, that if somebody else attempted to deposit or transfer money into the trust account, that TD would have prevented them from doing so?
Now I'm articulating to what they will accept. When your name is on the signature card, when you're the trustee for the trust, they will accept payments. That person is able to move money in and out of the account.
Now,
TD Bank had a copy of the actual trust.
we can talk about that too, sure. TD Bank did have a copy of the trust, right?
Yes,
And that was faxed to them?
yes.
And that was faxed. It would appear from a Square One office, right?
I'd have to look and refresh my memory on your document.
Okay.
I do know it was a fax.
Okay. I have it here, if you'd like to see it. This is D40, it's the trust documents, but they're the ones from TD Bank.
Yeah, we already showed it though, right? As exhibit.
It's a different document, Judge, because it
Oh, it's
has,
different?
well, first and foremost, it has the fax information at the top of it.
Can you just show it to prosecutors so at least they-
Sure.
I'm sorry, tell me the number again, please.
D40.
D40. Okay.
Okay?
Okay. Is that what you were talking about? The one that was faxed to TD Bank?
I believe so. This appears to
Identify
be
the
one.
document for me.
Sure, Your Honor. This is the Keith Caneiro irrevocable trust agreement. It is dated July 27th, 1999. Are there any more identifiers you would like?
I think there was something on the front page that counsel said was important. I just need to know, is that a fax copy? Is that what we're talking about?
It does appear to be faxed.
Okay. All right. Very sorry about that. Didn't mean to slow you down. Go ahead.
Thank you, Judge. So, you know what, while we're here, we see that it starts at page 4, right?
Yes,
Of the fax starts at page 4,
right.
right? And then there's a bait stamp at the bottom.
Yes,
And the bait stamp is basically placed there by the prosecutor's office, right?
correct.
Okay. If I were to thumb through this, you'd be able to see that there's no pages missing from the Bates numbers.
Correct.
Right.
Yes.
But the interesting thing about this document, the one that was sent to TD Bank, is that the trust is numbered. The trust agreement is numbered in terms of pages, but it's missing page 6.
Okay,
And page 6 is where, in the other copy, in the actual insurance policy that Canada Life had, in that copy, page 6 lists the beneficiary information.
that is what TD Bank sent. It's very difficult to get documents going back that far. And the fact that it's not complete is not a surprise to me. You're talking about an account that was opened way back when, and we subpoenaed this in 2018.
Well, let me just let you take a second look at this, though. Because if we go back to D40, right?
Yep.
And I go to page 5 of the trust document itself.
Right,
That's page 10 of the fax that was sent to them,
right.
right? And if I go to page 7,
Yep,
because we're missing page 6, it's
Right.
page 11 of the fax.
right.
So it was actually, when it was sent to TD Bank, it didn't include the beneficiary information.
Okay,
It's the way it would appear, right?
that's the way it appears.
And this is the copy that was to go to TD Bank in order to open and administer the trust account, right?
The business checking account, which was the trust account, yes.
But the trust account,
Right.
right? And Paul Caneiro was, as of this date, also listed as the trustee of the trust, right?
Yes,
But somebody, and obviously Paul Caneiro was going to, as the trustee, have control over that TD trust account, right?
correct.
And he was going to have control over the documents that were part of that account, right?
Specifically, what documents are you referring to?
Well, it could be foundational documents, it could be bank records. He would have access. You're just telling me about they'll accept checks from him because he's the trustee. So he's got certain privileges in this account that other people do not, correct?
Because he's listed as the trustee.
Right.
Right, so he would be getting the bank records, yes.
Right. And so obviously as the trustee, he's got access to these documents related to the trust from TD Bank.
That I don't know.
You know,
I don't know.
let me, I just want to stop this so we're clear. You know that the insurance company will accept a check from Paul from any account because he's the trustee, but you don't know if Paul has access to documents in possession of the bank related to the bank account?
I'll address the first part. Canada Life accepted checks from Paul Caneiro because I have evidence to prove that they accepted it. You put it in as an exhibit, I have it in my report. They accepted those 2 checks in 2017. When someone's listed as the trustee, the financial institution is going to deal with them and accept his check. With regard to having his name on the TD bank account that was set up to collect the premiums to pay to Canada Life, the individual, the signer on the account, Paul's the trustee, signer, he would have access to the bank statements. Does that mean a bank is giving you copies of everything they have in their file? Every bank has their own policy and procedure for how they handle that. Was Paul the one that physically handed that policy or physically faxed it? If he wasn't the one who physically faxed it, if it was another person who faxed it, did Paul or did Keith give that person who faxed it those documents? I don't know who gave him the documents to fax. That was how many years ago? So I do not know, and I can't say for certain if TD Bank is going to give the defendant or anyone who's listed as the trustee all the documents they get to open up the account. Look at the statements,
So that was a lot of maybes, right?
but it's the truth.
Another maybe is maybe whoever faxed that to TD Bank, knowing Paul was the trustee, didn't want to include that beneficiary information in the trust document that they were sending.
I wouldn't know that.
Because maybe they didn't want Paul to see that he was a potential beneficiary.
Aren't we speculating? Is someone going to see that? I'll say it. Speculation sustained.
Sign the trust. Can I be heard for a second, Judge? I'm sorry.
No, Miss Wallace,
Sidebar or here?
come on up.
I actually am surprised that the prosecutors had not said speculation. There's not really a lot of objection going on here. And I know that they want to give a wide berth for a fair trial, but speculation is not allowed without evidence. And how is this witness supposed to know what the bank would have done? However, those of us that do a little bit of business here and there and, have some knowledge of this stuff, although never would I claim to be an expert in any of this stuff, but would it not go to reason that the trustee of the account itself, with full writing, withdrawing, and depositing privileges, would be able to ask for the documents? Yes, perhaps. Also, is it not reasonable? Let me just put this out there, to withhold the beneficiary information anyway, because that is not something the bank needed in its private and proprietary. It's just not necessary. They need to know that the trust that exists, that it's a full trust. Do they need to know where that money's going to go afterwards? No, I don't believe so. Because I assure you, if they did need to know when they received that contract with the missing page, they would have asked for it. But beneficiary pages have people's social security numbers and information, stuff that they probably didn't need since they're not associated with the account. Just saying.
Everyone do me a favor. You stand up. Who can touch the ceiling? Anyone? Let's take a little stretch. I just want you to take a quick stretch. Look around.
Oh, I love it, Judge
Crack their own
Newman
back.
style.
You guys can do it? All right. Or you help me out. Got some issues. Lower part.
Another thing is going to remind me of the murder trial about these gays.
Just take a second. I understand that we're going for a little while here, so.
Oh, you gotta love a judge who loves a good stretch and appreciates
Comfortable, you can sit back down.
what sitting all day does to a person.
Just change at ankles. It's stuck on this angle.
I hope some of you, like me, are finding more and more things to like about this judge.
Summer, are you ready? You need a minute.
Just one more minute.
Take your time.
Okay, they're just, I know they want to bring these stuff in. We all know the defense's main objection here is to muddy the waters, make the investigation look flawed. They only looked at Paul Caneiro. The more they throw in there to muddy it, the more the actual evidence doesn't look like you can actually trust it, right? And that's defense 101, and we totally get it. But it has to be substantiated. You can't just willy-nilly throw things out there. You can't. You can't make phantoms. You can't grab at straws. Here we go.
We've heard a lot of information about various business accounts today, right? And you actually at one point in time differentiated between an operating account and a payroll account, right?
Yes,
And there were two businesses in this case. There was the J. Martin Square One business, and then there was EcoStar, right?
correct.
And obviously, they were both owned by the same people, right? But they were technically two different businesses.
And they had different ownerships in each business.
Right. But they had the same physical location, for example.
Yes,
And the same owners in the years that you were evaluating the case, right?
yes.
So the question I have for you was, it's not like it's illegal for a business owner to take money from their own account and put it into their business account, right?
It's not illegal if someone takes money from their own personal account to put into a business account? Is that what you're asking me?
Yeah.
No?
It's not illegal if somebody does the opposite, takes money from the business account and puts it into the personal account, right?
The mere fact of a transfer is not illegal, but I would have clarifications on that depending what your other questions are.
Yeah, okay, that's fine. I'm just saying in the abstract that in and of itself is not illegal.
Correct.
And just because something's labeled a payroll account doesn't mean that you couldn't take money from that account for purposes other than payroll, right?
Right, it's just this, and in this case, it's another checking account at TD labeled payroll.
And you could also just as easily put money into a payroll account. It's fine for an owner to do something like that, right?
Yes.
When you looked at the J. Martin account,
Operating or payroll?
when you looked at 1396, the operating account, you noticed that there were operational costs, including American Express bills, right?
Yes.
And you actually obtained the American Express records for that bank account, that were getting paid by that bank account, correct?
Yes.
Did you review those records?
American Express was well over 10,000 pages. I had my hands on it to review. So a review can be scrolling through. A full-blown analysis would be, analyzing every purchase and every payment made.
So which did you do?
It depends what account he's talking about.
Okay. You want to get specific, Mr. Marc?
So this is account 4003. I could show, if it helps, I'll just show it to you. Okay.
Please, thank you.
Sure. This is D61. It's not the full records, it's the part one of those records.
Okay. Would you like me to articulate what I'm looking at?
Yeah, sure. that'd be
Okay.
good.
These are American Express statements. It's a business platinum card in the name of J. Martin Consulting, Keith M. Caneiro. The closing date on the page I'm looking at is December 26, 2016, and it's account ending in 4003.
Okay, thanks. Did you review the records related to that account?
I would have reviewed them, yes.
Okay. So you would have seen that Keith, Jennifer, Paul, Tiffany Rivera, and Larissa Glorioso all had cards on that account.
I would have seen that, yes.
And you would have seen that over the course of 2017, for example, Paul's total charges to that account were $18,487.
I don't remember specifically, but I would have reviewed it.
Okay. And you would have reviewed the fact that Keith had a total spending of $104,549 on that card that year, right?
I don't remember specifically, but I would have reviewed that.
And specifically, Jennifer had spending of $27,750 on that card that year.
Again, same answer. I don't remember specifically. He is a 90% owner of that business.
And your understanding was that Jennifer worked there or did not work there?
My understanding is that she did not work there.
Did not?
Did not.
Okay. And then I'm just going to show you also this is D62. Here's it's the same account, right?
Okay. Do you want me to articulate what I'm looking at?
Sure, thank you.
Okay. This is American Express statements for a business platinum card in the name of J. Martin Consulting, Keith M. Caneiro. The date of the statement that I'm looking at, the closing date is January 26, 2018, account number ending in 4003.
You reviewed these records also, right?
Yes.
And so going to later in the year, we would have seen that a person, aside from the names that we already mentioned as card holders on this account, a different card holder by the name of Konstantinos Karidis was added to the account.
Okay.
And to your knowledge, that was not an employee of J. Martin or Square One, right?
To my knowledge, no.
And to your knowledge, Square One really had one main client, right?
One main and several other smaller clients, yes.
And their main client was in New Jersey.
Correct.
The checks I just did. So now, if there was, to your knowledge, did Square One have any clientele in Greece?
Not to my knowledge.
Okay. You issued several reports, in this case in the year, 2 reports, I should say, in the year 2025. One of those reports, the purpose of it was to correct some errors you had made in your previous reports, right?
Yes.
You, I believe, initially left out that Paul had received an additional $63,000 in money from Social Security Administration in 2017.
Now, the correction for the Social Security amounts is this. The defendant received 2 large lump sums from Social Security. And let me refer to my report so I can articulate accurately. Okay. Okay. In 2017, Paul received 2 large lump sum payments from Social Security. The first was on July 12th, 2017, in the amount of $61,535. The next payment was 6 days later on July 18th, 2017, in the amount of $63,101. So in my initial report, I added one of those numbers twice. In my second report, I corrected it so I could include both numbers accurately. So we went from 139,798 to 141,364. An addition error.
Now, one of the things you did when you wrote your first report was you characterized transactions between Paul's personal accounts as revenue to him.
Revenue stream, not revenue in the sense of a salary. A revenue stream would be available for you to use in that year. So if revenue came into that account, if that's what you're referring to, it was available for use in that year, used to pay expenses.
Right. I was just looking at the titles to your pages of the breakdown of income and expenses. It doesn't say revenue stream, it just says sources of revenue / income.
Sources of revenue, a stream of revenue.
But then you updated that and you took that information out of your report. You took those sources, those transfers between accounts out of your report.
Because I wanted to give the defendant the benefit, and in that area, it was determined that bank account revenue sources, because the amounts were determined to be duplicative. So I didn't want to utilize an amount twice. I re-reviewed the report and I gave the defendant the benefit.
I mean, is it about giving him the benefit or reporting the right numbers, though?
Both. Because hypothetically, if it was 20,000 in the first report and I re-reviewed it and it was determined that the amounts were duplicative and it was 10 and 10, then I'm saying your revenue's 10 instead of 20, as an example.
I mean, maybe I'm just confused. Because I thought that the net impact of you making that change, correct me if I'm wrong, I thought the net impact of you making that change was that it reduced your conclusion of Paul's revenue by $22,000 in 2017,
Right.
and it reduced your conclusion of Paul's revenue by $57,000 in 2018. Do I have that right?
Oh, not for that topic. You're talking overall in every category that an adjustment was made. Are you speaking just to the bank account revenue sources, which was deemed duplicative and it was eliminated for 2017 and 18?
I'm talking about yes, what you characterized as revenue. Yes.
Okay.
Now, so you're saying that when you wrote your first report, you knew that you were including that information as revenue. And then when you wrote your second report, you knew that you weren't including it as revenue.
When I put the motive together and wrote the first report, then after that, I had time to really go back and re-review. And I made sure that the numbers were accurate. And in this instance, I removed it because I realized it had been duplicated.
Okay. Now, you also corrected, I believe, various entries that you made in that report about an auto reimbursement for 2017, right?
Which one are you referring to specifically?
What's labeled as 2017 auto reimbursement? $27,290.11.
Okay. Okay.
So in the first report, you had calculated that differently, right? And then you had to go back and you had to make a correction to that report, right?
Yeah, I'll tell you exactly what it was. It was a check in the amount of $375 that inadvertently ended up being in that area when it shouldn't have. So I reduced the amount of the auto reimbursement because I took out that check that should not have been there. So it was reduced by $375.
I mean, it's a minor point, but you know that those numbers only come to 27,290 if you include other miscellaneous reimbursements from the payroll other than the auto reimbursement, right?
The auto reimbursement, there is a line item on the payroll journals, and it tells you exactly how much it is. So,
Right. Yeah, I have them.
okay.
But you know that when you calculated that number, you included miscellaneous reimbursements, not just auto reimbursements.
You can show me the statements from TPP payroll journals. To my recollection, it said auto reimbursement.
Okay.
Counsel?
As we go through another sidebar to hear out this issue, here we come again. Okay.
All right, ladies and gentlemen, even an earlier day today. Thank you. Nothing. I'm kidding. So I'm going to let you go for today. It's been a long day for you all. I'd rather have you back fresh tomorrow morning. So I'm going to let you go home. You'll do the same thing tomorrow as we did today. You'll be downstairs at 8. We'll get you right up here by 8:30 and get you started. But let's get you out of here for today so you can get home. So as a reminder, you're going to hear me say it every time we leave each other. Don't discuss this case. Don't do any research. I'll see you back tomorrow morning at 8 a.m. Have a good night. Be safe. Thank you.
Okay. So trial is over for the day. We shall see. I'm going to wait because I think they may have a discussion after. What he is letting the jury go. It is close to 4:30 where they are done for the day. But there's some issues that need to be discussed. Today has been a lot of back and forth, a lot of sidebars, and the judge himself putting his own objections in to where some of the questioning was going. And he didn't seem, in all honesty to me, he didn't seem too pleased with either side about the issue. No one's being clear. He said he needed to do some research. They came back in defense. Mr. Murray had said they're not going to go there with regards to the one particular email, and yet they still are dwelling in older financial information and accounts that were not part of the actual transferring of funds and the charge in regards to Paul Caneiro's offense of fraud with the trust account. And I believe, it appears to me, but who knows, I'm not on the defense team, obviously, but it seems like these lawyers are trying to muddy the waters by saying, look, like, moving money around was common in this family. This is what they do. I mean, oh, look, Keith Caneiro even moved money out of the country. He had a home in Greece. And, yes, of course, you're going to have to finance stuff there back and forth. That's not so unusual when you look at the whole context of it. Well, that seems to be the judge's issue. If you're going to piecemeal it and put it out there, then you have to at least allow the whole picture to come in. And that is a very valid point. When it comes to law, the judge is right on that. And ultimately, it's his decision. I realize it's hard to go through all that financial information on a day, but this is actually key testimony to one of the main other charges against Paul Caneiro for the misappropriation of funds and fraud, and also his motive as to why it was necessary, or he felt it was necessary, for the crime to be committed. This is a key part of the motive that the prosecution is trying to lay out. And as we all have learned, it's really going to depend on how a jury takes it. I mean, what sounds substantial to us, or the zinger or the nail in the coffin, so to speak, often we have heard later that a jury just passed it over, meant nothing to them. They didn't get it, or they didn't find it relevant. It's all in their perception. And that is what I love about watching live trial. Seeing it, seeing what the jury gets to see, and trying to go with the information and only the information that the jury is seeing. Remembering that we get so much more information out here than they do. We have looked into the case and looked at all the filings and watched all the hearings. We have so much more in our heads than the jury right now. But they have to make their decision based on only what happens during the trial. Only the evidence that gets presented. And more than just the evidence, how the evidence gets presented. Is it in a way that they can actually understand where they're going with it, understand what it actually means to the case on either side, prosecution or defense? Okay, they still have, okay, here we go.
To like the prior years, and then there was the exchange today between Your Honor and Mr. Murray and the courts, whether the court was on notice. And I just want to clarify, in the state's original letter of intent that we've discussed before, this is from 2020. The state indicates in its letter, for years, defendant had transferred money from the TD Trust bank account into his personal bank accounts. Defendant paid the monies back to the trust account completely in 2014 and mostly in 2015 and 16. In 2017 and 2018, though, that's where the unauthorized takings are alleged. So that was originally submitted, like it was out when I came into the case in January. I had this letter and this letter only. It was my understanding that this case was about 2014, 15, 16, 17, 18. And then we filed a response and Your Honor signed an order. And in the order, Your Honor recaps the facts of the case. And this is on page 12 of Your Honor's order, and says the letter emphasized that the falsified records would be used to show defendants submitted fabricated statements, and that the timeline of the financial conflicts between the brothers stretched from 2016. So I think Your Honor is referring to the facts alleged that I just read from the letter. And then Your Honor finds ultimately what's admissible is it includes 2000. It includes that time period. I think it's on page 63. So it was our understanding all along that
Includes
was
what years? 2017 or 16?
16. But that was based on the facts that Your Honor was summarizing from their facts, but their facts had 2014 and 2015. Then we filed the motion for that they needed an expert to present this testimony. And that's when we said, look, we have 50 reports from Detective Bassinder. The information needs to be synthesized so we know exactly what they're relying upon. And then in July, the end of July is when we received her expert report. And that's when we learned for the first time that she might only be testifying to 17 and 18. But that doesn't mean that we weren't under the impression this entire time that that time period was relevant. The obviously, defense to theft is money was paid back, money was paid back, money was paid back. And then the indictment focuses on those 2 years because that's what they're alleging. But it doesn't mean that the entire, time period isn't relevant, nor that it wasn't previously discussed in the state's own facts.
Here's the problem that I have. I'm going to say you, but it's your team. The defense had no problem with filing whatever amount of motions they wanted to file. I gave everyone the opportunity to file them. I then, after the Supreme Court got involved in our case, I specifically asked if there was more to discuss. By then, you have the July report. You have all the opinions by the court. If there was clarification that was necessary, we could have clarified it. We're now in the middle of trial, in the middle of a witness with jurors here, and the state's only providing 17 and 18 based upon what the indictment is. If you want to go into 14, 15, and 16, I get it, but that's not where the theft is. So to me, I would think that you would need to have to give me something to support the fact that because he paid in 14, 15, and 16, that means that he's good for 17 and 18 because, maybe he would have paid it back, or I don't know what you're going to try to insinuate. But the reality is this. I mean, I don't know how else to say this. Just because somebody does 50 things right in their life, if they then do 5 things wrong later in their life, that doesn't mean that the first 15, 20, 50 things, whatever they are that are right, means that that's a justification for what happens later. And I think that's what you're trying to say. So to me, I'm more than willing to listen. I'll work it out with you guys. But I'm just saying we should have been filing motions if we wanted to bring in something. The indictment is all that we should be talking about is 17 and 18. If the state started going into 14 and pushing all of this other stuff right now as a part of their bad acts towards 17 and 18, you guys would be standing up complaining about the fact that you're going into other time frames so that Paul Caneiro knows what he's doing when he's not paying them back. So I just want to be very careful. I'm willing to listen. I've said it 1,000 times. So far, all I'm saying is that what I've just seen here today, we have gone well beyond the direct. Nobody has filed said any objection, so I've let it go. But we're going into areas that, to me, I'm not sure that we should be in. If we're going into them, if both sides agree, so be it. If you guys want to agree to that, go ahead. But to me, the indictment is the area of where we're in. My opinion may have talked about those dates because it was within that motion, but the indictment's still the indictment. So That's the area that we're playing in. Ms. Mastellone, I'm going to let you finish because you started before I let Mr. Decker say anything. Go ahead.
No, just, the only point was that this wasn't a surprise to anyone. And the 2014, 15, 16 timeframe was in the state's original, hey, this is what we may intend to present at trial. We were on notice of those years. We assumed those years were encompassed. Just because they provided an expert report in the late July for a September trial date that didn't include the rest doesn't mean that we were under the impression that it wasn't relevant. Of course it's relevant. In fact, it's interesting that originally they acknowledged monies are paid back, monies are paid back, monies are paid back. And then they're like, oh, but we might not talk about that. We just want to talk about this. And that's, concerning, but it's relevant.
But there's parts that weren't paid back between 14 and 16, right?
Yes, and we went into that. So we were fully forthright about that.
My point only is that the decision was made by the state to not start the indictment in 16, 15, or 14. They made a decision, or the grand jurors made a decision, to start in January of 2017. So to me, going back 14, 15, and 16 has nothing to do with what happens in 17 and 18, unless somebody's tying it in. And just because the state put that in that notice of intent, I had to make the determinations of what we were going to talk about, and I was looking at the confines of the indictment. But let me hear from Mr. Decker.
Judge, just for the record, as far as the notice of intent that we filed in 2020, and I'm not going to rehash this, but it just has to be said, that document is completely meaningless at this point, because for 5 years, we were under the impression, and the defense was asked numerous times, are you going to file any motion? Are you going to file any motion? We all know things changed. I've said it a million times. I don't blame Ms. Mastellone. Don't blame Mr. Murray, but that document's value is a little bit sketchy at this point in time. That being said, I just wanted to clarify one minor point. I'm not trying to go anywhere with it, but one of the things that we said at sidebar with respect to that objection about when the court was talking about speculation and the like, is I think the point I was trying to make was that I thought Mr. Murray had asked the witness about the Keith Caneiro irrevocable trust agreement that was faxed, the copy of it that was faxed to TD Bank, the one that was missing page, I think it's 6.
My understanding of the question dealt with where did it come from? How did it get there? Maybe this person, it could have been this, it could have been that.
That was part of it, Your Honor. But I think the last question that spawned the objection was intimating, or at least asking, whether, basically saying that Paul Caneiro did not know that he was a beneficiary of that trust, despite the fact, the first time we've ever heard that, but also despite the fact that he's the trustee and he signed it. That I believe that was the point they were trying to make. So I'm just clarifying that. We're past it, I think, but I just wanted the court to understand, I believe that's what the question actually was.
Well, let me just say this. If I got lost on the question, God only knows on what's going on with the jurors as they're listening to this testimony. Go forth as you need to go forth. Again, I'm not slowing anyone down. Just think about what you're doing and how you're doing it. All right? So, look, Mr. Decker, let me be abundantly clear. Are we getting into documents from 2014, 15, and 16? The defense is basically saying they want to bring all this stuff in. Are you of the position, you and Ms. Wallace, no disrespect, you can stand up and answer too. I don't care. What are we talking about? Are we talking about all the documents? Are we talking about 17 and 18? What are we doing?
Our direct was limited to 17 and 18, and that is what the state is talking about. I don't see how the fact that the defendant may have paid back monies to a trust account in 2014, 15, and 16 is relevant to what he did in 17 and 18.
Okay. You've now heard it. If you guys have a position on that, you want to supply me with something as to why you feel the need to go further, you already have. But if you want to do it.
I was just completing the record because it appeared that you were saying to Mr. Murray
Oh,
that
my.
the court wasn't aware that 14, 15, 16 was a thing. It was a thing because it was in the original letter. That was all. That's the point. So it's that it wasn't a big surprise today there's been a lot of litigation in this case already. It was a while ago. It was earlier last year when we handled these motions in March, April, May. So I understand that it's been a while, and I was just trying to show that, this was something that was addressed previously at this time frame, and it's done. We're done. There's nothing more.
Okay. Anything else? See everybody in the morning.
Okay, well, that's going to be us for the day. I do find it very interesting what's going on about the dates and trying to get in there to muddy the waters in regards to the financial information. It seems the defense's angle is that they want to say this was routine. He always paid it back. It was no big deal. Well, the judge made a very valid point. Like, if you bring in all of those years, there were times he didn't pay it back. And so that's going to stick out. And then also saying, like, we've been doing hearings since 2020 when that letter came out, and not once have you said any of this. And the prosecution's been pretty clear in submissions afterwards that they were focusing on the period of time of the indictment, which is what the judge's order said, which the indictment was clear for 17 and 18 years, 2017 and 2018, in regards to the financial misappropriation of funds, which leads to the motive for the murder. Now, I don't understand why prosecution, while all this was going on to date, was not objecting to scope, to relevance, to outside of scope, because the way I understand it, and I'm not a lawyer, and I don't pretend to be, but I've watched a lot of trials. I love the law. I read legal briefs every single day. I am immersed in this stuff as much as I can. Not an expert, don't pretend to be, don't get me wrong. But common sense would say that in the rules of direct and cross, as far as I understand it, and please, anybody out there with more knowledge than I, correct me if I'm wrong, cross is only based on the direct. You're not allowed to go out of the out scope of that. It's you can object. And yet I didn't hear it from the prosecution at all. And I kept thinking about it all day. And if you noticed, I was pretty quiet because I was like, this doesn't make any sense. I don't want to say something out of turn. I don't want to put something out there that's just like, ridiculous. And the only thing I can come up with is they were hoping to open up a window somehow to more. Now, after doing some research, I found that there were other instances where Paul Caneiro may have had some problems, okay? And we're not going to get into that because that's not fair and it's not part of this trial. But that is the only thing that I can see as to why they weren't objecting left and right. And they were quite quiet, I do think that Christopher Decker at the end brought up a very valid point about the missing page with the beneficiaries on it. I understand that the bank really doesn't need that or whatever, but to try to insinuate that means that they didn't, that Paul Caneiro had no reason to kill Keith Caneiro because he wasn't going to be a beneficiary is hogwash, because it is true. As the trustee, he had to sign the agreement, which means he has all the pages and always did. He's the trustee. That's just hoping that the jury doesn't understand the responsibilities of a trustee and the documents that they're entitled to. After all, Paul Caneiro signed that document. Missing page or not sent to the bank, he signed a document that had all the pages. Yes? I ask you, meet me in the comments because I want to hear about you on this one. This was driving me crazy today. The fact that we had one witness all day and we were just going back and forth about what testimony we could actually hear. And it was a financial crimes detective from the Monmouth County Prosecutor's Office who is very versed in researching financial crimes. And it should have just been about the financial crime. But all of a sudden it got into people's demeanor, who knows what, when, what access to what they were thinking. How would that witness know? Anyway, just a thought. Meet me in the comments and hopefully meet me back here tomorrow. Have a good night.